There is no gentle way to introduce today's case. I don't have a quippy, relevant life story that can transition us into the introduction of the fact. The bald truth is that I'm sharing this case because I fear that history may repeat itself. While the Army learned valuable lessons from the My Lai massacre, it did so reluctantly, slowly, and without public support. This is Conduct Unbecoming. I'm Erin, and I'm your host. In March 1968, Charlie Company served on Task Force Barker in the Republic of Vietnam, charged with subduing and driving the Viet Cong out of an area popularly known as Pinkville, apparently named Pinkville based on the population density. The area was considered a stronghold for the Viet Cong, and previous ventures into the area drew sniper fire, machine gun fire, mines, and other attacks resulting in American casualties. On March 15, 1968, Charlie Company held a memorial service for their fallen colleagues, those they'd lost in the preceding weeks. The commanding officer for Charlie Company, that's Captain Ernest Medina, briefed attendees to the memorial on their task for the following day. Intelligence indicated that Charlie Company might face an enemy battalion in My Lai 1, 4, 5, and 6, and that civilians would be absent from the area. Charlie would lead the way for Task Force Barker as they moved through the operation. Captain Medina later recounted his instructions to the troops that they were to destroy My Lai 4 by, quote, burning the hooches, killing the livestock, closing the wells, and destroying crops and food. Someone in the briefing asked what they should do if the reports were wrong, if there were women and children, civilians, still in the area. That soldier asked if he should kill them. Captain Medina clarified that they should not kill women and children, adding that they should use common sense. If the civilians had a weapon and fired upon the soldiers, then they could retaliate. First Lieutenant Calley remembered a different answer. The Miami native remembered hearing that they were to kill every living thing: men, women, children, animals. Others in the crowd remember varying instructions in between, which just seems wild. I don't think there were any legal advisors in the room, but there were strict rules of engagement designed to avoid committing war crimes, to reduce or otherwise eliminate civilian casualties. In inhabited areas like villages replete with civilians, commanders in direct contact with the enemy could only authorize direct fire if their mission was in jeopardy, the enemy was positively identified, and even then only for defensive purposes. When March 16th broke, Charlie Company climbed into 9 helicopters to be transported to the area. Lieutenant Calley's was one of the first platoons to arrive, and they set to work establishing a defensive perimeter to secure the area for the rest of Charlie Company being dropped in. In the process of securing the landing zone, the platoon did not receive any hostile fire from the nearby village. That village consisted of about 700 residents who lived in a variety of brick homes and thatch-covered huts. Along the eastern edge of the village ran a drainage ditch, or an irrigation ditch. The northern boundary transitioned into deep jungle, while the southern boundary consisted of an open area used for village meetings. They encountered only unarmed, unresisting men, women, and children. The platoon rounded up the villagers who had learned a vital phrase in English and repeated it: "No VC, no VC." Calley and his platoon began to move them to collection points. Lieutenant Calley attested that he received multiple radio demands from Captain Medina seeking to learn what the holdup was. Calley said that after he explained that they'd encountered unexpected civilian villagers, he was directed to waste them, and that he obeyed that order because the military taught him obedience. He could perhaps have used a reminder that you only follow lawful orders. So Lieutenant Calley approached one of the collection points in the open area to the south and told Private First Class Meadlow, who guarded a group of 30 to 40 old men, women, and children, that he knew what to do. He later returned and asked why the old men, women, and children were still alive. Meadlow said that when Calley told him he knew what to do, he hadn't actually known what to do and thought he meant just guard them. He didn't know that Calley meant murder. Calley opened fire on the group, and Meadlow may or may not have joined. It's kind of unclear. During the shooting, Calley expended 4 or 5 magazines from his M16 rifle. When only a few children remained standing, Calley shot them personally. Calley and Meadlow moved to that irrigation ditch nearby, encountering another group of civilians being detained by soldiers. This was a bigger group of civilians from My Lai 4. Meadlow estimated there were between 75 and 100 people gathered. Calley told Meadlow they had another job to do. Calley also ordered other soldiers to open fire, which they refused to do. One specifically refused to lend his machine gun to the killings. Calley used between 10 and 15 magazines during this phase of the attack. It's sort of unclear what else was going on, what other soldiers were involved at this point in the massacre. But I think given the casualties, it's clear that it wasn't just Calley and Meadlow. An army photographer embedded with the company later described seeing about 30 soldiers kill approximately 100 civilians. He remembered attempting to focus his lens on a young child, but being unable to snap a photo before, in his own words, the child was blown away. Calley and another soldier moved to the northern end of the irrigation ditch, finding an elderly Vietnamese monk. He conducted what's described as a brief interrogation before striking the monk with the butt of his rifle and shooting him in the head. For what it's worth, Calley admitted striking the monk, but denied shooting him. There are conflicting accounts, but it's estimated the rampage in the rural Vietnamese village lasted nearly 4 hours. It stopped only when soldiers flying overhead spotted women and children in that ditch. When the helicopter set down, 2 men approached. Pilots asked the soldiers if they could help the women and children out of the ditch. They replied that they would help them out of their misery. The chopper took off, and over the din of the swirling blades, the crew heard the sound of machine gun fire. They radioed headquarters to report the massacre before landing again. The pilot ordered his crew to evacuate the civilians, and by some accounts, ordered them to shoot any American soldier who interfered. In 1998, the Army finally recognized the soldiers who intervened, awarding Hugh Thompson, Larry Colburn, and Glenn Andreotta with medals for their heroism. That medal for Glenn Andreotta was awarded posthumously, because he was killed in action 3 weeks after his act of heroism. News of the massacre was very, very slow to leak. Reports detailed the operation as a victory, describing 128 enemies dead and only 1 American casualty. A cursory review conducted later indicated approximately 20 civilians had been inadvertently killed. But it's not actually clear how many Vietnamese civilians died during the massacre. Most counts put that between 300 and 500. Hugh Thompson, the pilot of the helicopter, filed a complaint alleging war crimes. it went ignored. It wasn't until November 1969, approximately 18 months later, that the story finally broke and the Army's Criminal Investigation Division began to dig in. I don't have concrete details on how many witnesses or potential witnesses died while the Army shirked its duty to investigate. Charlie Company had continued to operate. Meadlow lost a foot to a mine explosion shortly after the massacre and returned to the United States. Although dozens of soldiers were charged with various criminal offenses, the legal responsibility fell to First Lieutenant William Calley, that platoon leader in Charlie Company. Prosecutors promised Meadlow immunity from military prosecution in order to secure his testimony against Calley. But during his first trip to the witness stand, he refused to answer any questions about the massacre, asserting his Fifth Amendment right against self-incrimination. When he was recalled to the stand, the military judge warned him that if he refused to answer questions, 2 U.S. Marshals would take him into custody. So he submitted to questioning, and prosecutors elicited details of the incident. In his defense, Calley elected to testify. Perhaps rather unbelievably, he testified that he couldn't remember a single Army class on the Geneva Convention on the Laws of War. What he could remember was a warning that he could be court-martialed for refusing to obey an order. He accused other soldiers of beginning the massacre, finishing with the assertion that he acted as directed and that he did not feel wrong in doing so. That it did not feel wrong to shoot infants in their mother's arms. Despite the number of soldiers charged, only Calley was convicted. He was convicted of the premeditated murder of 22 infants, children, women, and old men, and of assault with intent to murder a 2-year-old. It took the panel of 6 officers 13 days of deliberation to arrive at a verdict. He was sentenced to confinement for life, serving only a handful of days in custody before the first in a series of commutations. The lead prosecutor on the case wrote a frank letter to President Nixon detailing the fairness of the court-martial, the constant public scrutiny, the seriousness with which the panel discharged their duty. He expressed his wish that, quote, all leaders of this nation, which is supposed to be the leader within the international community for the protection of the weak and the oppressed, regardless of nationality, would have accepted and supported the enforcement of the laws of this country. The prosecutor told Nixon that his intervention, quote, damaged the military judicial system and lessened any respect it may have gained as a result of the proceedings. That he subjected a judicial system of this country to the criticism that it is subject to political influence, when it is a fundamental precept that the legal processes of this country must be kept free from any outside influences. It's not clear to me, of the dozens of courts-martial that resulted in acquittal or were dismissed, what theory cleared those soldiers. I suspect, frankly, it was a lack of public support. The takeaway from the Nuremberg trials was that the Nuremberg defense, a defense built around just following orders, was not a viable legal defense. And Captain Medina was prosecuted on a theory of command responsibility, but he was acquitted. After the statute of limitations ran on perjury, he admitted he had suppressed evidence and lied about the number of civilians killed. The statute of limitations also helped him dodge a related dereliction of duty charge. At court-martial, Calley did offer the Nuremberg defense that he was just following Captain Medina's supposed orders. But the panel considered that defense and rejected it, with the benefit of hearing from witnesses to the briefings and the operation as a whole. His defense also asserted that the stress of combat impaired Calley's thinking, and he wasn't capable of premeditating the murders. Following his conviction, Calley appealed to the Army Court of Military Review, the precursor to the ACCA, which affirmed the findings of guilt and sentence. Next, Calley took his 30 asserted assignments of error to the Court of Military Appeals. the precursor to CAF. The CMA took an interest in 10% of those assignments of error, evaluating first whether the public attention on the case prevented a fair court-martial. The court concluded that although coverage of the massacre was extensive, a considerable amount of the coverage was sympathetic. Much of the remaining coverage was factual and neutral, highlighting that Callie had not yet been tried. And the court observed the publicity wasn't something the attorneys or judge shied away from. They conducted thorough voir dire, issued orders to prevent discussion of the case, and insulated the panel from further press coverage. Callie's second assignment of error was that there was not enough evidence to establish his guilt beyond a reasonable doubt. The court concluded otherwise, holding in part that enemy prisoners are not subject to summary execution by their captors, and that military law has long held that the killing of an unresisting prisoner is murder. They determined that even if they accepted Callie's argument that the Vietnamese villagers were, quote, the enemy, he had no right to kill those under the control of American soldiers and who offered no resistance. I don't think it's a stretch for the panel or the appellate court to conclude that an infant is obviously not the enemy. In the final assignment of error, Callie argued that the panel was improperly instructed regarding malice aforethought and on the defense of complying with superior orders. There's both a concurring opinion and a dissenting one, which I suppose does not surprise me about this case. Many politicians had taken Callie's side following the massacre, and those around Fort Benning, where Callie was court-martialed, treated him like a hometown hero. Restaurants refused to let him pay for his meals, and fellow patrons were fond of buying him a beer. I'm hopeful that things would be different if Callie took these actions today, in a time where access to news is instantaneous and where technology makes it easy to capture and share digital photography and videography. The media coverage of the massacre was largely sanitized. That's what the court concluded. And I think that means most people back home had no idea they were buying a brewski for a man that murdered a monk and children. Although the levels of seriousness are vastly different, it makes me think of the McDonald's hot coffee case. When people hear of the case, they think of an elderly woman who was just feeling litigious about the warmth of her coffee. But when you dig into the case and see the horrific pelvic burns that required skin grafts, it makes the original $2.7 million in punitive damages make a lot more sense. But maybe I'm just naive and hopeful that it's ignorance of the facts that led people to court Callie after he returned accused of war crimes. The dissent takes what I perceive to be a bold position regarding the Nuremberg defense, and in its opening paragraph asserts that the standard applied in the majority opinion permits, quote, serious punishment of persons whose training and attitude incline them either to be enthusiastic about compliance with orders or not to challenge the authority of their superiors. And, it complains, the standard also permits conviction of members who are not persons of ordinary sense and understanding. And I think it's really bold because it's saying that there are going to be brainwashed and/or stupid service members who will follow orders blindly, and we shouldn't allow them to be punished. I understand that a drafted armed service is different than a volunteer force. But surely we can agree that the young people we elect to arm should be people of ordinary sense and understanding, and should be able to understand that the mass murder of unarmed civilians is wrong. Even though he was sentenced to life, Callie served 3.5 years under house arrest at Fort Benning in Georgia before being released to live out the rest of his life as a civilian. He passed in 2024 at the age of 80. It's my understanding that he didn't express any regret or apology until 2009. Thank you for listening. If you enjoyed today's episode, please share it. I invite you to submit case suggestions or feedback to conductandbecomingpod@gmail.com or on conductandbecomingpod.com. Join me next time when we return to a single victim case and the issue of victim medical records. Until then, take care. Conduct Unbecoming is a podcast where I get to talk about interesting crimes and cases that involve U.S. military service members. I research, write, and produce the podcast myself. And perhaps it's obvious, especially with this episode. Conduct Unbecoming is not approved, authorized, or endorsed by the Department of Defense or by their new preferred name, the Department of War.